Good afternoon, everyone. My name is Guillermo J. I'm an attorney here at Frier Levitt, and we thank you for joining us on how to respond to document requests, audits, and overpayment demands. Just a little bit about myself and our firm. My name is Guillermo J. I've been working here at Frier Levitt for almost 3 years. We are a national boutique law firm located in New Jersey with offices also in New York and soon another new office in Manhattan. We are exclusively healthcare and life sciences attorneys. That's basically what we do every day. And I wanted to talk to all of you today about something that has been really taking up a lot of my time in the last 3 to 5 years, which has been the increased crackdown on physician practices, namely investigations by governmental agencies, investigations by the OPMC, by the Department of Health, and of course by federal and state regulators. So what I'd like to talk to you about today is we'll break it down into 3 separate sections. One is how to respond to document requests. Now, document requests and investigations are somewhat synonymous with one another. Usually, when you receive a request for documents from a state or federal agency or from a licensing board, it usually has to do with an investigation that they have. Either they identified you as a potential target or subject of an investigation, or they received a complaint about you or your practice, and they have to look into the matter further. The lowest level way for them to do that is just to request documents. Now, why do they request documents rather than just come in and talk to you? Well, it's simple. Documents, unlike testimony, you have no Fifth Amendment privilege. So you have no constitutional privilege and no constitutional protection with what's written in a document. Whereas if someone asks you for a statement, you can always decline and say no and claim a constitutional protected right against self-incrimination. So speaking of investigations, what do we mean by that? Well, first of all, you have to understand that next to nuclear energy, healthcare is probably one of the most scrutinized industries in the United States. You're talking about regulations at the state level and also at the federal level and by private commercial carriers. You have basically every alphabet soup organization in the United States looking down on you. If it's a workplace issue, it might be OSHA. If it's how you discard of your medical waste, that might be something from the EPA. If it's HIPAA protected materials breach, that's the Office of Civil Rights, OCR. So every acronym you've heard of, they have their hands in the cookie jar. They are regulating you. That's why the healthcare industry is so highly scrutinized and one of the most scrutinized industries in the United States. The 3 main areas of concern that the healthcare industry should be aware of is, number 1, fraud, waste, and abuse. Every year, the government comes out with new findings talking about how many hundreds of millions of dollars and actually billions of dollars with a B are actually being paid out inappropriately by Medicare and other public programs due to fraud, waste, and abuse. Now, fraud, for the most part, is pretty standard. That is, when you bill for a service that you don't provide, when you bill for a service and lo and behold, you're out of the country, things that are impossible. That's a pretty clear a pretty clear instance of fraud. Waste and abuse, that category can just be medically unnecessary testing. It could be maybe practicing defensive medicine where there is no legitimate need for that. for that. So we're talking about a much more gray area. And that's where you see a lot of auditing and where they think there's possible waste or abuse. Diversion and indiscriminate prescribing. That is the opioid epidemic that we're going through right now. That is bipartisan. That is in every state. That is across the country. And that is one of the few things that everyone in this country can agree is a problem, regardless of what side of the aisle you're on. And that is going to have the highest level of scrutiny. If your practice if you practice in pain management, or if you have a primary practice where you do some pain management, or where you have where you dispense regularly Schedule II drugs, you must have an opioid compliance plan to make sure that you're protecting yourself, your staff, and your business. Last is Anti-Kickback Act violations and the False Claims Act. We see that most often in a couple of areas. In one area, it's where you enter into a contract with a vendor. It could be maybe a lab company who sets up a lab in your office, or somebody who's subleasing space or giving you a contract as a consultant, and the value is not based on a fair market value assessment. That's where you'll see a subpoena usually from a governmental agency, from a prosecutor's office, where they're asking you for copies of contracts, consulting agreements, etc., with a particular corporate entity. Those focus in on, are you receiving money in exchange for potentially giving out referrals? That is something that is a violation of the anti-kickback statute. The other thing that we see a lot is in the anti-kickback realm is when you have a agreement to provide services or to have a teaching agreement, an educational component, and it's a no-show position. You basically get a flat fee every month or every year, and you don't really have office hours. You don't really teach a class. You don't really provide consulting services. Those are these no-show positions where the government takes a position that the only reason you're getting that is because you're giving access to your patients to a potential entity. So those are the three areas that we've seen increased subpoenas on and increased document demands. So if you have any of these types of agreements, if you have anything where you're prescribing a lot of Schedule IIs, if you're using a particular code or procedure with a high volume, that will make you very likely to be audited or to have a document demand or subpoena issued, because they're going to be investigating your outlier status, or they're going to be investigating your relationship with maybe a hospital or a lab company or somebody who has contracts with a lot of providers in your area. Now, moving on to the next slide. So licensing boards, if you receive something from the OPMC, that's usually in response to a complaint by a patient. It could be a complaint by a colleague. It could be that they found, that you maybe had a DUI, or you were arrested, or you were indicted, and it came down through the National Practitioner Data Bank. For the most part, state investigators, they're the ones who conduct, the OPMC investigations, and that's not something that I get concerned about until there's something to be concerned about. The best way that I could put it to you is usually OPMC, when you get a complaint from them, they will allow you time to prepare documents responsive to their request, prepare sometimes a written response. They'll give you an opportunity to give a phone interview, or if you don't want to do that, to prepare a written submission. So there are ways that you can allay concerns the OPMC may have, and that's something that you don't have to worry about. OPD usually are the state investigators that do the OPMC's investigative work. It's much more likely that you'll receive a visit from OPD investigators who, which should be noted, are not specialists in healthcare. An OPD investigator may be at an ENT practice conducting a thorough investigation one day, and the next day they might be doing an investigation or on-site review of a deli. They are not specialists in healthcare, so when something's at the OPD level, you really need to make sure that you educate them as much as possible to make sure that they understand what you do, and to get legal representation to make sure that they understand that you're doing everything correctly and according to OPMC regulations. Now, if you fail to comply with the OPD, with OPMC requests, that can make you that can lead to discipline on its own, because you have a duty to comply with an OPMC request. And the OPD usually has subpoena power. That means that they can force you to produce documents. So OPD, OPMC, they use subpoena power. Subpoena and a warrant are two completely different things. Sometimes we've seen investigators come into an office and the way that they represent the power of the subpoena, they make it sound almost like it's a warrant. Like, I have this subpoena, you must provide these documents to me immediately, right away. That's not the case. If someone has a subpoena and serves you with a subpoena, you have a reasonable amount of time with which to respond. That usually means about a week or two. So if you get a subpoena, you do not have to give those records that same day. So it's very important that you know your rights, because if you don't, an investigator can take advantage of the fact that you may not know the difference between a subpoena and other forms of document productions. Now, state agencies, for instance, like the New York Department of Health, they have more power than OPD. A lot of times, the Department of Health can conduct unannounced inspections, and the Department of Health sometimes will work in tandem either with a state attorney general's office, OPMC, OPD, or other agencies. So you have to just be mindful of who's in the room with you when you're answering questions. As far as investigations from a federal agent, usually they involve more serious allegations. Federal agencies and federal agents focus on, larger exposure or a larger potential fraud. Usually more than one agency is involved. You see it usually a DEA agent for opioid case. A lot of times the FBI will accompany OPD if it's a joint state and federal investigation. The FBI, they do a lot of the investigation for the federal government. So the FBI's agents are typically seen in tandem with DEA agents and other agents from other federal agencies. The important thing to keep in mind, the federal government does this a lot. They will do what's called a parallel investigation, where while they're gathering facts, while they're getting documents from you, talking to you, talking to your staff, talking to your patients, while they're gathering all this information, their investigation is going on parallel tracks. If what they find leads them to believe that you have only civil liability, then they will pursue a civil case. If they think what they found leads them to believe that there is possible criminal exposure, then they'll go after, the criminal side. We represented a case of a physician in upstate New York who was tried criminally for a $12.5 million alleged Medicare fraud. So what we came to learn is that federal agents investigated him for 10 years. Now, during this 10-year period, they talked to every single doctor and nurse that worked with him. They put a tracking device on his car. They did everything you could imagine, everything you could think of, everything you've seen in movies to try to get incriminating statements. At the end of the 10-year period, they decided they were going to go criminal with it. So during the 10 years, they could have gone either way, but they eventually had enough information that they thought this was a criminal case. Thankfully, they were wrong about it. We were able to win at trial, but This, don't ever underestimate the power of the federal government. That was a 10-year investigation that included, tracking, his movement, bugging his car, sending in undercover agents to record conversations, flipping one of his employees against him, talking to, coworkers, talking to nurses, talking to everyone they could think of. And again, that goes to show the depth that they will go to try to prove a case. Common misconceptions. This is something that I want everyone to pay attention to. If you only pay attention to one slide in this whole presentation, pay attention to this one. Common misconceptions. So investigators do not have the duty to tell you the truth. Investigators, can lie to you. They can deceive you. They can mislead you. If a DEA agent comes in and says, "Listen, I know that you prescribe what correctly, but this one patient of yours received, this prescription, and I think that you're clean, but there are 3 other doctors who also prescribe that patient this drug, and I think one of them is dirty. So if you would just surrender your DEA license now, and then at the end of this investigation, it's only going to take a few more months, we'll give it back to you." So I've had doctors give up their DEA registration, and then all of a sudden, a few months later, the investigation is over, and what do we hear? "Oh no, well, we can't give that back to you. You have to reapply for it, and you have to come back." And the reapplication process, and trying to do this during an ongoing investigation, it might take a year and a half before you get that back. Investigators do not have a duty to tell you the truth. The power of the subpoena. The subpoena is just a piece of paper that says you have to produce records by a certain time. That's it. A subpoena can be quashed, meaning that you can go to court and have it be considered invalid. If the subpoena is unreasonable, if the subpoena is incorrect or deficient in some way, you can quash a subpoena. So it's not the same as a warrant. A warrant, someone comes in, you have the right to remain silent, and that's it. They can take whatever records is on that warrant in the room that is outlined in the warrant. A subpoena is completely different. They just give you a list of records that they need, and you give it to them in a reasonable amount of time. Investigators do not want a statement. They want a confession. An investigator has a lot of cases. An investigator has a lot to do. They're not interested in sitting down and just chatting. When an investigator gets to you, you have to understand where they are in the process. The process is they receive the complaint. Maybe they obtained copies of medical records, either directly from the patients or through a subpoena or through other means. And then, after reviewing records, after talking to patients, after doing their own investigation, they come and talk to you. They come to talk to your staff. You are near the end of the investigation, not at the beginning. So they already know a lot before they talk to you. They have their mind made up of how they think things are. When you talk to an investigator, they're not going to write down everything you say, show it to you, let you make corrections, and then have you sign it. That's how a proper statement is taken. What they're going to do is they're going to talk to you, they're going to listen to you, and they're going to write what they think they heard. And then their original notes from your conversation are going to be torn up. So all of a sudden, your statement, your voluntary statement, becomes whatever they heard, whatever spin they want to put on it, and that gets memorialized in a report of theirs. Your original statements are nowhere to be seen again. So again, investigators, they're looking for a confession, they're looking for an admission, they don't want just a statement. And last but certainly not least, cooperation means future consideration. That is absolutely untrue. If you cooperate, you may give up your right to remain silent. You might give up your constitutional right. Something you say may be misstated in a report. Something you say may be confused. Just because you cooperate doesn't mean that the person who's smiling at you in your office is then going to be smiling at you later down the line. Some of the most effective investigators come in, smiling and being super nice, and then, you turn around and they're an absolute jackal once they have everything that they wanted, and a statement that they can then use, to their advantage. So cooperation doesn't mean future consideration, because you will not have any consideration just because you spoke with the investigator or handed over the records in a timely fashion. Lastly, we're talking about an investigation. What do you pay attention to? Again, the tone. Do they come in like a bull in a china shop? Who's the investigator? What agency are they with? And then again, how many agencies are present? The more is not the merrier in terms of investigation. The more agencies, the more potential exposure, the more agencies investigating you. These are things to take into consideration. When someone comes to you, they hand you a subpoena or they ask for a statement or, whatever, you just have to say, okay, thank you. I'm going to cooperate, because a lot of times you have a duty to cooperate. And it's always better to cooperate, but with this caveat, you do it through counsel. If you do it on your own, when you don't know what they're looking for, when they're unannounced, and when they catch you by surprise, that's when you're likely to say something that, will come back to hurt you, come back to haunt you, something that's inaccurate, something that, now come to think about it, the answer really wasn't that, it's this. It's better to say to them, listen, my attorney will contact you. Leave me your business card, and I'll have my attorney contact you. That is the best way to deal with investigators. Investigators, even if they're from the OPMC or OPD, they don't have a right to come in and disrupt your patient practice. So you can absolutely tell them, we're busy with patients right now. I don't have time to talk to you, but I will gladly schedule a time when you and I can speak. Please leave me your number. And then you give that number to your attorney, and your attorney can do some kind of digging into why they're there, what they want to talk to you about, et cetera, et cetera. It may be in your best interest to talk to them. It may not be in your best interest to talk to them. But you can't make that determination on the spot. When you get a document demand or a subpoena, look at it. Is it specific or is it broad? If they're asking for 5, 10, 15 patients, that's not something to be worried about. If you get a 7-page subpoena asking you for 50 different records, there's an issue that they're focusing in on. And you want to make sure that you're not a target or a subject of that audit, of that investigation, be it criminal or civil. What type of records are being requested? If you see a lot of financial records, personal records, contracts, then it might be a anti-kickback issue. Then it might be looking at a violation of the False Claims Act. If they're looking at just pure patient records, then it might be a billing question. Just by what type of records are being requested, that should key you in as to what you should be looking out for. Now, audits, that is unfortunately an area that has been receiving a lot of attention lately. Over the past 3 to 5 years, I can tell you that audits have gone through the roof. Whether you're out of network or in network, doesn't matter. You will be seeing an audit sooner or later. The reason why is simple. What they do is insurance companies contract out with independent contractors, these data mining firms. They give them all their data based on the CPT codes billed, the procedures done, et cetera, et cetera. These data mining companies then turn around and tell them, okay, well, these are the most billed codes by your providers, and these are the 10 providers, 100 providers in the state of New York who do this the most often. And then what they do is they subdivide that. Okay, well, these are the 10 in, New York City, in Manhattan, who do this procedure the most. And in Orange County, these 10 physicians bill 99245 the most. They find a way to divide and subdivide by specialty, by county, by, geographical location to determine how you can become an outlier. And then they compare you to your so-called peers, which a lot of times when we do some digging into it, it could be as few as 3 to 5 practices, and sometimes they're not even directly related, particularly if you're a specialist and your area of specialty is very unique. So when you get these audits, what are they looking at generally? Generally, medical record audits are targeting a lot of evaluation and management codes, E&M codes, diagnosis codes, and what they're trying to look for is weaknesses in coding and documentation. They know for a fact which codes are misused the most. If you sit down 6 coders and you give them a chart, it's going to get coded 4 or 5 different ways. Coding is largely subjective, and that's why they're focusing in on a lot of E&M codes, which are very subjective in nature, and they're also focusing in on high reimbursement procedure codes. So how do you find out that you've been audited? All right, so how were you notified? The first thing you want to know is, in an audit, is this audit routine or is it a targeted audit? Is there some red flags I need to be aware of? How were you notified is a big issue. Were you notified because someone called you? Did someone show up on site saying that they needed to review records? Did you get a letter? And if you got that letter, who addressed the letter to the practice? If you ever see Special Investigations Unit, SIU, next to the investigator's name, they are concerned primarily with fraud, waste, and abuse. That means that they're looking to recoup money, possibly also look into fraudulent practices. So anything addressed from an SIU, you want to get an attorney involved as soon as possible. You want to get a certified professional coder involved as soon as possible to also independently review whatever claims are going to be reviewed during the audit. How many charts are being requested? This is a big one. So if you have a 10 chart request, 15 chart request, that's not something that I would get, too worried about. 10, 15, 20 charts, that's not a significant amount. Once you start getting around 50 charts, and I think 50 is usually the magic number, 50 usually gives you what's called a statistically valid random sample. Now, why is a statistically valid random sample important? It's important because under New York law, if you're going to extrapolate, you need a significant enough sample size, a statistically valid random sample, to be able to extrapolate. Meaning that if you look at 50 charts and it's for consultation codes or a new office visit or whatever code it may be that you're reviewing, if you take a look at 50 charts and you find 100% error rate, what that allows you to do is extrapolate now to 5 years, beyond the statutory limit, 24 months. So now you can go back 5 years, and by going back 5 years, you can say, okay, on this code over the last 5 years, we paid $1.2 million, and based on our statistically valid random sample, 100% is likely to have been paid incorrectly or overpaid. So they're going to recoup the difference in code and the difference of that 1.2 million between what you billed and what they think you should have billed. That difference may be 200, 400, 600,000, who knows. If it's a code that they say is completely unreimbursable, there's no levels to it, then they would look back to get the full 1.2 million. So it's very important in these situations to get a certified professional coder, one who has particular expertise in reviewing codes of your specialty or subspecialty, and challenge every single finding. Get an attorney to try to negotiate the look-back period, the number of documents to be produced, and the final overpayment demand or overpayment settlement as well. There are ways that you can get around this. There are ways you can defend this, but again, how many charts are being requested? That's a big decider whether it's going to be routine or whether it's going to be problematic. Lastly, if it's pursuant to a provider agreement, if you have a HEDIS audit, that's not really an audit. That's something where the Medicaid Advantage companies have contracted with CMS to routinely look at even 50 charts, 100 charts, just to determine that the provider is complying with Medicaid Advantage and that the patients are Medicaid Advantage patients. There's also other audits where there might be 7 patients, but again, it's just pursuant to your provider agreement. They'll come in and they'll look at 3 or 4 charts, provide a little bit of on-site education. Those are not issues either. When we're talking about issues, we're talking about red flags. So audits, if you see that there's an audit from a RAC auditor, a recovery audit contractor, that's a red flag. If it's a ZPIC, that's a red flag. There are buzzwords like, oh, we've noticed, that there were some billing irregularities, or we found that you were an outlier for the use of whatever code. Those are red flags that they're looking to hope that they're looking for a post-payment audit that's going to focus on an extrapolation and usually an overpayment demand. Again, if you see a large number of documents requested, that should be a red flag right away, because that means that the more codes they're looking at, they'll need about 50 charts per code. So if they're looking at 3 codes and you get 160 patient overpayment document request, that's something to be very wary of. There are also some specific procedures or codes that are always going to be potential for high auditing. If you use a lot of modifier 25, modifier 59, those get audited all the time. If you use consultations, those are, again, one of the hot button areas for auditors. And if you have a procedure that you perform within your specialty that reimburses at a high rate, for instance, for ENTs, balloon sinuplasty, those get audited very frequently because there's questions of medical necessity. Were conservative measures exhausted before you ended up doing a balloon sinuplasty? So there's a lot behind the decision to audit. Another red flag is the in-office copying of records. Now, with the emergence of EMR, that has been problematic, because what they'd like to do now is say, listen, we'll come to your office and we'll copy all the records. You don't have to worry about anything. You don't have to worry about, anything other than just giving us access to one of your terminals, and, we'll make sure to print out or download every record that we need. There are a couple of reasons I don't like that. One, I don't like you handing over a terminal to somebody who has no use for it. There's other patients from other carriers that they don't have the right to their information. You may have a system where you get alerts for medications, for patient, maybe even patient communications, or requests for a refill, that, again, they're not entitled to see. So, again, that's something that you need to be wary of. The other reason I don't like in-office copying of records is because of the fact that a lot of times what they'll do is they'll go in and then they'll say, well, by the way, Doc, how do you bill modifier 25? What's the rationale behind it? What is it? Can you define it for me? They'll start quizzing or interrogating the doctor and the doctor's staff. How often do you do a balloon procedure? How much do you usually charge for something like this? Or these questions are all going to come back to haunt you or your legal representation when you want to try to negotiate down the line. Nobody is perfect. That's the reason why they do these audits, because even a very well-run practice is going to have some errors here and there. And when you look at a significant sample size, you're going to find 1 or 2 charts where maybe you didn't do everything you should have done. You didn't document everything exactly like you did, or you should have done, or to do. So that leads to overpayment demands, and it's really hard to really negotiate when they say, well, listen, I'm not going to negotiate on this code because your doctor already told me that, he doesn't know what he's doing, because when I went to his office to copy records, I spoke to him about it and he didn't have the right answers. Just because you don't have the right answers that day doesn't mean, or the textbook answers, doesn't mean you don't know how to use a code, you don't know how to bill. That's why we say, listen, if someone absolutely, positively has to be in your office, don't talk to them. Okay, give them access to the records, put them in a back room, give them a terminal if they need a terminal, and then, create a firewall around them. Nobody talks to them, they don't talk to anybody, and that's it. Audits, do's and don'ts. So you have to comply with the audit. That is, a must. If you don't comply with the audit, what happens is you get a 100% error rate. So complying with the audit is a must. Copy all records, intakes, diagnostic testings, operative reports, anything that supports the date of service at issue. Sometimes it will tell you the specific date of service that they're looking at. Other times they won't. Whenever they're looking to review whether you did a certain test, whether a certain E&M code is supported, just make sure to always send in everything that's relevant, everything that's germane to it. Some practices have EMR, and some have handwritten notes, and some have a hybrid. If you have a hybrid, send the EMR notes and any contemporaneous, relevant handwritten notes. Some practices that have written notes will have an intake sheet that gets updated every time, and then the progress notes separately. Send both, because the intake is going to be part of your history. It's going to be one of the elements they're going to look at for E&M codes. That's an easy way to fail, or the contrapositive is it's an easy way to pass. So again, make sure you send everything that supports the treatment that you're rendering. Don't give statements or hand over control of your workstations. If you absolutely have to hand over control of your workstation, that should be a last resort. If you can put one of your own employees, a staff member, an MA, somebody to print out, to save, to a hard drive, to do whatever they have to do with your records. If you can put one of your own people on the terminal, that's best. If you can't, that's the last resort, but try to keep them off of your workstation. Also, don't send illegible records, sparse records, or fail to keep a copy of what was produced. I'll work backwards on this one. Failing to keep a copy of what was produced only works to hurt you. You need to know what was sent in, because if you're going to fight their findings, if you're going to say, wait a minute, but you didn't review everything that was relevant, or hey, you missed this, you're not going to be able to make that argument. You're losing all of those arguments because you don't know what they took. You don't know what they copied. That's why you should always have a copy of what was produced. If they come over to your practice and they download records from your EMR, ask them for the exact dates of services for each patient that they're looking at. You are entitled to that, and you should know that. Sparse records, we just talked about that. You want to send everything that supports the date of service at issue. And lastly, don't send illegible records. If you do have handwritten records, send them in as legible a manner as possible. We had a physician that we represented one time who was asked for a number of records, and he was upset about the number of records he had to produce. So he thought it would be a good idea to produce these records, and this is years ago when everyone was on handwritten records. He produced them on red paper. So he printed them all out, or he copied all of them on red paper. Now, why is red paper relevant? Because now when the insurance company wanted to make copies, you can't copy anything that's on red paper. It just comes out all black. So he thought he was being, funny. He thought he was sticking it to the man. Well, because of that, they gave him 100% denial rate because they said that all of his records were illegible. It took a lot of fighting and a lot of appealing and a lot of apologizing until we were able to resubmit the records in a much more legible format. But again, this is what happens. You send something that's illegible. You send something that has a lot of abbreviations that are not common abbreviations, but abbreviations that you use that you know what they mean. If you don't send them those abbreviations, the records are illegible to them. Make their job easier to review because they're not going to work hard to try to understand what was written. Audit response plan. So once you get an audit, once you find out you're the subject of an audit, what do you do? Well, first of all, determine the intent of the audit. Is it a rack audit? Are they going to be looking to take back money? What is it? Conduct a self-assessment. You need to understand if they're saying that they're going to come in and look at DMEs. You're a podiatric practice. They want your L3000 forms. They want to see, what you're dispensing. They want to see what DMEs you're ordering. They want to see proof of casting and everything. Okay, conduct a self-assessment. Do you have all of that? If you don't, you're going to have a reason why you don't have all of that. So conduct a self-assessment first. This might include getting a certified professional coder to review your documentation before they get there. If you find a mistake, correct it right away. It goes a long way to correct something before you're told to correct it. Beware of deadlines and ask for extensions. So if you have a written request for records, a lot of times they'll ask you for records by a certain date. If you do not give them by that certain date, then they'll be considered, you'll be considered non-responsive, and you may even fail the audit. They'll ask for 100% repayment. Ask for extensions. They will readily give those. Depending on how scary of a situation, depending on what's being asked, how many records, determine if you need an attorney, a coder, maybe even a statistician. If their sample is too small and they're asking to go back for years, then maybe they don't have a statistically valid random sample. That's a way to attack an audit. And remember, the most audited areas, they're consults, high-level E&Ms, modifiers like 25 and 59, and of course, any procedure that reimburses at a high amount. So you've been audited, and now you got an overpayment demand. How do we deal with those? Well, a lot of this is going to sound very similar because it's very similar to what we've discussed already. Overpayment demands in general, they're secondary to audits and document demands. They can be based either on documentation. Sometimes it's a failure to credential because you might have a non-credential provider providing services. That usually you see that with Medicaid Advantage plans. They could also come because of requests for records targeting a potential kickback. Remember we were talking, in the beginning of the presentation about how sometimes you'll have a request for records from a federal agent or from a prosecutor's office, maybe a large subpoena asking for copies of contracts, consulting agreements, lease agreements with a vendor. If they think or if they find that vendor agreement, that contract, that consulting agreement, that lease agreement was not a fair market value, then they're going to say that every single time that you referred a patient to that entity, that payment that was made was based on an illegal relationship that violates either the False Claims Act or the Anti-Kickback statute, and they're going to request recoupment of that money. Any services that you provided, any remuneration that you received, that's going to be requested that you pay it back. So again, whether it's from a criminal investigation, civil investigation, or just a straight up audit demand, overpayment demands can come from many different areas. Impact of on-site copying versus production. We discussed this before. So on-site document inspections really can expose you. If you can't avoid it, just make sure to instruct your staff accordingly. Make sure that they don't have any conversations other than something that is very vanilla. You don't want them talking about how you bill something, the type of patients you see, how many patients a day. Their interaction should be very straightforward. It should be, yes, here is the bathroom. Yes, here is our examination room. Here is where we keep records. It should be only to help them conduct their investigation and get out fast. It has nothing to do with explaining how things work at the practice. Again, anything said to an investigator can and will be misinterpreted against you. That goes back to what we talked about earlier when we talked about cooperation doesn't mean that you'll get consideration. And again, production, when you produce records as opposed to someone copying them on site, it allows your attorney and your experts to give context to what they're seeing. Sometimes, when you produce it, you might give an explanation as to what they're going to be seeing. Is an overpayment demand looming? Well, again, we're going to ask a lot of the same questions that we were asking about whether an audit was problematic. How many documents are being requested? Who is requesting the documents? Does it relate to some hot topic area or some area that's frequently audited, like high E&M codes, things of that nature? Is the request general or specific? you can usually see when an audit is going to lead to an overpayment demand. Now, common mistakes with overpayment demands, again, we've talked about a lot of this. Not keeping a copy of what was sent out or copied. Giving a statement without first speaking to an attorney. It's not that you can't speak with an investigator or that by saying, you know what, I'm not going to speak to you today, contact my attorney. Doesn't mean that you'll never have to give a statement or never have to speak to them. But just like, if you ever had a medical malpractice, lawsuit, you would get an attorney and, the attorney would help you defend it. You would have a deposition at some point. And before that deposition, if that attorney is worth anything, in my opinion, what they do is they call you in the day before, 2 days before, they sit you down, and they go over with you questions and answers. This is the type of questions you're going to receive. How are you going to answer them? Because how you answer something and what you say can be misinterpreted. So you need to be super clear about what you say and how you say it. That's why we stress don't talk to anybody when they just show up unannounced, when it's a surprise. That leads to a potential to just basically say something that you don't want to say something that is wrong, say it in the wrong way, say something that may get misinterpreted. This is why you take your time, you gather your thoughts, you figure out what they're looking for, and then you can give a statement, usually with being accompanied by your attorney. Another common mistake is producing incomplete or illegible records. Again, once they ask for records, send as much as you need to support what they're looking for, to support the code that you use, the procedure that you use, the medical necessity, to show that you exhausted conservative treatment. These are things that you have to do because it's going to hurt you if you withhold anything. Again, you can't treat all requests as routine. If you get a large request for documents, you have to give it the proper importance. And then lastly, not reviewing what is being sent out. That is something that's very important. I represented a doctor in the past who basically produced records that, unbeknownst to him, were altered by one of his staff members. They added something to the record, which, again, there was no reason for that person to add it, but that person added something to the records. The reviewer, the auditor, then looked at the records and said, "Wait a minute, what's this that's been added? I'm looking at other records you've produced to me, and this one looks like you added information, like you added things that weren't in all the other records." And then when we found out what happened, we had to explain ourselves. Not a good look. It's not a good look. It's not good optics. It's particular when they're, alleging fraud, or they're alleging waste, alleging abuse, to produce a record that has an alteration on it, to produce a record that's not 100% correct, for the wrong patient, for the wrong date of service, that has, notes on it or redactions that shouldn't be. That's a bad look, and you want to avoid that at all costs. So how do you respond to an overpayment demand? Well, you fight every one of them. Sometimes they may be low. They may be $10,000, $7,000. And again, not to say that $10,000, $7,000 isn't a lot of money. It is. But a lot of these high exposure ones, you're talking about seven figures. They're looking at 1 to 3 million back. Your average one that has come across my desk is usually around $500,000 to $600,000. So when we're talking about overpayment demands, if they're requesting less than 50, it's usually relatively a low amount. But you fight every single one of them. You fight a $1,500 overpayment demand because you don't want to become low-hanging fruit. And when you don't fight and you just write out a check, you're more likely to receive a future audit than if you fought them every step of the way. Determine if you have any potential insurance coverage. Sometimes your medical malpractice insurance company will have a rider that gives you coverage for legal fees and expert costs. That's invaluable. And if you do have that, then you especially want to fight every single overpayment demand, even the most de minimis demands. Don't ever give insurance auditors the benefit of the doubt. A lot of times, when we've done our reverse audits of their findings, when we had our independent certified professional coder take a look at the same records, we find out that their coding was way off. There have been instances where they have alleged 100% error rate, where our independent coder saw 0 error rate. So we have, there's a lot of subjectivity to coding, and you certainly don't want to give them the benefit of the doubt. When it comes to medical necessity, one thing that we have seen time and again is that their challenges to medical necessity are either based on what a certified professional coder decided, and they don't have the subject matter knowledge to make a determination about medical necessity, or it's made by a doctor who is not of the same specialty as a doctor being audited. So if you're an ENT and a dermatologist is looking at medical necessity for a balloon sinuplasty, that's not correct. You need to know who made that decision. So if they're talking about medical necessity, ask for the CV, the identity, the credentials of the medical director who reviewed it. Statistical sampling. You need to make sure that, if they're saying that, they're entitled to go back 5 years to get an overpayment demand of, X amount of hundreds of thousands of dollars, well, do they have a statistically valid random sample for every code? Now, they may have requested 50, 60 charts, but if they're looking at 4 or 5 different codes, they need to have a statistically valid random sample for every code. So unless those 50 patients you build every code with every one of those patients, they're going to need, for 5 codes, 250 charts. Lastly, the look back period. This is where, as lawyers, we do the most of our fighting. There's a statutory limit in New York for how far you can look back. There's, of course, a very general catch-all exception when there's allegations of fraud, waste, and abuse. And that's usually the way that insurance companies get around the lower limit to go back 5 years, multiple years. And that's something that, you have to be very cognizant of. So final thoughts here before we turn it over to some Q&A is you have to understand the healthcare industry is highly regulated and it's full of pitfalls. There's, many doctors who had the best of intentions who unfortunately, didn't know what they didn't know. And when that happens, you think you're billing the code the right way because you've been billing it for years, you've been practicing for 20, 30 years, and then all of a sudden someone comes around and tells you, oh no, doctor, you've been billing 99214 way too often. You really should have been billing 213, so now we need you to repay us 5 years worth of the difference between a 99213 and 214, which can be in the 6 figures. Handling a matter in-house really can cost you more than getting the right experts involved, particularly if you have insurance coverage for it. You really need to figure out if that's the case. Take time to determine if something is routine or not. Don't treat everything as routine, and you also don't have to, lose sleep over a 5 record demand. Just treat it with the commensurate amount of respect based on the demand. And last, use your common sense and trust your instincts. I've had a lot of doctors tell me over the years, I had a bad feeling about this audit, or, something told me that this code, we were probably, we were probably given the wrong advice to bill it. It's probably not correct. Trust your instincts. Use your common sense. If I can impart any bit of advice to you is regardless of the size of your practice, but especially if you are a solo or you have a small practice, you absolutely cannot afford not to know what gremlins you have in your records. You should have a certified professional coder do an independent audit of a sampling of your most used codes. You give them 20, 30, 40, 50 charts, have an independent coder on your dime do this audit. That's going to reduce your risk considerably because whatever your auditor finds won't lead to a 6-figure overpayment demand. It'll only lead to a corrective action plan where you change around a couple of things, you make sure your documentation is up to par. You make sure you're compliant with all CMS, commercial, payer, and other regulations, and that lets you at least have the peace of mind that you don't have something in your records that can be cancerous that could one day come back to bite you. So with that being said, I want to thank everybody for attending. If there are any questions right now, I will answer them. If we've run out of time for the questions, what I will do is, you can email me. My email address is up right now. Any of the questions and whatever questions I get in the next couple of days, we will send out, a blurb to everyone who participated in today's, all the attendees. We'll send you basically a mass email with the questions and answers that we receive in the next couple of days. So at this point, let me turn it over to Katie, and I don't know if there are any questions that we have right now.
Hello, Guillermo. Thank you.
Hi.
So we have a couple questions. The first question we have, one moment. Okay, the first question we have is, when Mr. Beades mentioned 50 files as a threshold, does he mean 50 different patients or 50 distinct patient encounters, some of which may be with the same patient? For example, if it's a record for 50 patients, it could mean hundreds of encounters aggregate.
Yes, that's a great question. Usually what they like to do is request 50 patient charts, and they look at 2 or 3 dates of services per patient. But usually if they're looking at one particular code, it may only be 25 patients, 25 charts, but it may be 3-4 dates of services. It comes down to the date of service, not the actual patient charts. So if you see that more than 50 dates of services are being requested, that's when I would start taking a closer look at the audit or document request.
All right. So our next question is, what's the best practice to show cash payments for copays?
So cash payment for copays, listen, there's no set rule on what to do. I would just make sure that it's documented in your file somewhere. There's some sort of documentation for it. Even if it's just a sheet of paper. If you have complete EMR, let's say, you don't have a way to put it in your EMR anywhere. Some sort of book where you keep a log of cash copays received, collected, because if you ever are audited on that issue, you certainly want to be able to show that. So as long as it's documented in some way, that's the most important thing. There's no set way that I've heard of. If I come across anything, I'll do a little more research into that. I will certainly send out a mass email to all the attendees and let them know.
Okay. Our next question is, are insurance companies allowed to automatically offset overpayment demands from future payments?
Yes. Usually the way it works is if you can't come to an agreement, they'll do one of two things. They'll either decide, after giving you the ability to appeal their audit findings, because you have obviously due process rights under your provider agreement. If after all said and done, they don't take you to arbitration or trial, they could reduce from your future earnings. Yeah, they could take from future payments.
All right, we still have a couple more questions. G, would you like to reach out to these attendees afterwards?
Yeah, what we'll do is, whatever additional questions we have, we will email everybody with some of the questions that we answered, and some of the questions that will come in the next day or two. And then, maybe by this Friday, we'll try to shoot out everybody some answers. So if you have any questions about these issues, feel free to email me, and I will, try to answer as many questions as I possibly can. We'll send them out this Friday. And again, want to thank everybody for participating in the webinar. I hope you found it to be, informative. And if you ever have any issues, please feel free to reach out to me or anyone here at Frier Levitt. We thank you for your time and hope you have a great day. Thank you.